This appeal was made at the instance of the contesting respondent in both the civil appeals, who was really aggrieved of a clause in the prospectus issued by the appellants, which according to her was not valid. Stop. According to the contesting respondents, she being a Canadian citizen is an NRI, that, therefore, she was entitled to seek admission to the MBBS course in the NRI category quota, but yet the definition of NRI as specified in the prospectus issued by the Chandigarh administration and the Government Medical College Chandigarh for the academic year 2012 to 13 would denude her of such status and therefore it was liable to be struck down. Stop. The contesting respondent claimed that her grandfather retired as an under secretary in the year 1994, that when he was in the services of the state of Chandigarh, he resided in a government house from 1964 to 83 and shifted to another government accommodation provided by the Chandigarh administration from 1983 to 1993, that third set of government accommodation was provided by the government to the father of the contesting respondent, which was occupied till December 2003, and that thereafter, her father started living in the house of her grandfather in Mohali. Stop. The contesting respondent claimed that she passed as a regular student from Mohali, that the prescription contained in paragraph 2 of the prospectus providing for eligibility and merit for NRI seats for MBBS course, stipulating that the grandparents or parents of the candidates should be resident of Chandigarh for a minimum period of 5 years at any time since the origin of Chandigarh, and should have immovable property in her name in Chandigarh for the last at least 5 years, and a certificate to that effect issued by DC estate officer or municipal corporation of Chandigarh. Stop. It was on that footing that a challenge came to be made by the contesting respondent in the High Court in CWP number 1423 of 2011 stop. The learned single judge by order held that the impugned clause was totally impracticable, illegal, illogical, and declared as such stop. However, the learned single judge went further into the question as to whether the contesting respondent can be granted admission.